Hello, I'm glad you're here. This is D.L. Hughes from velocitywriting.com, where you learn to write with speed, passion, purpose, and profitability. Creative Commons is confusing to many people. It's hard to find a simple explanation of it, and I'll be providing that in this video. Also, from interactions I've had, people seem to like good aspects of Creative Commons, but are totally unaware of some of the terrible aspects of it. That's why I'm also suggesting 6 scary things about Creative Commons. They may frighten you from ever using Creative Commons again. And that's all coming up right now. I'd like to invite you to subscribe. Also, click on the bell icon so you don't miss my latest videos. Getting new insights here? Well, then please like this video, make a comment, and feel free to share it on social media or your own website. There's more on this topic, including sources at velocitywriting.com. The direct link to the post is in the YouTube description. Let's start at the beginning to understand why Creative Commons even exists. As a content creator of any kind, you have intellectual property rights. No, I'm not an attorney, and I'd suggest you hire one if needed. Consider this an overview, commentary, and criticism of the topic, not legal advice. Any creator gets copyright protection in the U.S. the moment they turn their idea into tangible form, like a word processing file, a printed page, a photograph, a painting, a musical score, or whatever. Protection is immediate. You get additional protections and benefits when you register your copyright with the Copyright Office, but that's optional, and that's it. You can't copyright an idea, only the tangible expression of it. But here's the key issue. As a copyright owner, you can rent your work to others for various purposes. It may be you're writing an image, a video, or anything where you own the intellectual property rights. It's kind of like real estate. You own the house and have the right to rent it for income. In the case of intellectual property, you don't sell your creation outright. You do not issue a transfer of copyright. You can rent your intellectual property, and this is called licensing. The license gives the licensee the right to use intellectual property in one particular way for a specific time. They are not buying your intellectual property outright. They are paying a fee to use it. They are renting it. Creative Commons is like a giant clearinghouse for people who want to rent their intellectual property. The bad thing is that you get paid nothing when someone else uses your property. You are allowing anyone to use your work as long as the person using it abides by the Creative Commons license terms that you select. Any creator can license their original work under one of these Creative Commons licenses. Any other person can use the work in accordance with the license terms. Now, licensed Creative Commons intellectual property is not free, as many people think. You must abide by the conditions of the license. Now, here's the big question. If you are a content creator, do you want to release your work into the wild for no compensation and perhaps no accountability by the person who uses it? Well, for me, the answer is no. But I have licensed my work privately for a fee. Creative Commons is nothing more than a non-profit organization, not a governmental agency. Creative Commons licensing does not change copyright, fair use, or the public domain in any way. It is a licensing tool only. Since this is the case, why bother with Creative Commons at all? Got me. Now, let's turn the tables. I just talked about you being able to license your work to others if you wish. What if you want to use existing Creative Commons licensed intellectual property in your work? The images and other content are not free. there are rules associated with their use. You are taking a risk. That's why it gets scary, and you may find yourself getting scammed or in deep, expensive legal trouble. Each license comes with its own risk and restrictions. Here's scary thing number 1. There are 6 different licenses. Each license comes with its own risks and restrictions, as I've said. The only possibly safe license, in my opinion, is CC BY, and I use it sometimes. That means you have a license to use the text, image, or whatever if you give credit to the creator. Fair enough. So you might provide this attribution, CC 4.0 by J.J. Jones, for an image. That's reasonable. We always want to give credit where credit is due. Except, as we'll see in a minute, some are abusing CC BY, so that's trouble for you. Beyond CC BY, license requirements only get crazier, and that increases your risk, in my view. For example, the next less onerous license is called CC BY SA. Not only does this mean you must give attribution by, but you are also required to share alike. That's what the SA is. Creative Commons says adaptations must be shared under the same terms. So when you include any intellectual property license like this in your own work, you are forced to share your work on the same terms. Are you sure you want to license your own work that way? You may invest time and money making adaptations, but you gain no value for your work. You are working for free, and you lose control of it because share alike handcuffs you. Now, I have an attorney friend who calls the SA share alike license a virus that keeps spreading. If you use CC BY SA license content in your mix, then you become the victim of it. All the other licenses beyond CC BY SA are even more restrictive, and you may become entrapped if you use one in any way. For example, CC BY NC/ND means you really can't do anything with the intellectual property except maybe look at it. NC means no commercial use. ND means no derivatives. A third party can only look at it, not use it in any practical way. Perhaps this one should be called the narcissist license. It's a hard one to figure. These license requirements are the foundation of abuse, as we'll see. Creative Commons licenses can be misleading. Here's scary thing number 2. There is far more to using the intellectual property other than proper attribution. Creative Commons emphasizes the attribution in their headlines, but in the small print they say, the license may not give you all the permissions necessary for your intended use. For example, other rights such as publicity, privacy, or moral rights may limit how you use the material. How can you know if you are really free to use the Creative Commons licensed content? Well, you can never know unless you hire a lawyer who will research that particular piece of intellectual property. You are sometimes forced to show an advertisement in the attribution line. Here's scary thing number 3. We're seeing far more people using Creative Commons licensed images and other work used as advertising. Remember, you are required to use attribution exactly as required or be sued. So you'll have to trash your book or blog with an attribution line that says something like CC 4.0 by Wilhelm Vandersnut, photographer to the stars, Beverly Hills, California. Do you want to be forced to show an ad like that just to use an image or other creative work? Not me. This photo and attribution are illustrative and fictitious, of course, but there is a huge increase in this kind of required attribution. What if you don't show the attribution as the original content creator specifies? As you'll see, it seems some people are intentionally planning on suing you if you don't show their full attribution ad in your work. And you must use the exact attribution because that's what the license requires. And that leads us to scary thing number 4. You may get sued for using Creative Commons licensed content. Some people are using Creative Commons licenses to sue people just like you, even though you think you are using it legally. Some call these people copyright trolls. For example, the Technology and Marketing Law blog recounted the court case called Philpott versus WOS Incorporated. WOS used 2 Philpott photos, gave attribution, but not precise attribution, according to Philpott, so Philpott sued WOS for $150,000 per photo, and he won most parts of his case. The author of the article said Creative Commons may be weaponizing serial copyright litigants. They look for small Creative Commons licensing errors. When attribution has a tiny error, that gives them grounds to sue for copyright infringement. It is easy to get sucked into a lawsuit. For example, if you insert a photo from online using any of Microsoft software programs, it presents Creative Commons images for you to include. But look at this. It includes images that may land you in court because, as in this case, the buy credit is not shown. Unknown in the metadata is bogus, even for Microsoft. The missing name of the content creator is a violation of the license, and the person may sue you. Now, Microsoft's failure for not including it is irrelevant. What do they care? Also, note this images was marked NC, which means not for commercial use. So that means you can't use it in any project where you generate any income at all. I'm showing it under fair use, but still blurring it because this video is commercial use. I think communication scholar Melody, her PhD, was right on target. She said, infringement of copyrighted work offered under a free Creative Commons license can be quite expensive. Creative Commons is home to an abusive search engine optimization scam. Here's the deal. As TechDirt.com reported, people are actually changing the photo attribution credits on Creative Commons images. They are allegedly stealing credit because Creative Commons infrastructure allows that to be easily done. Then the person sends an email to everyone using the image and says, hey, you're using my image, so how about linking back to my website? But it's all a fraud to con you into giving these people valuable SEO backlinks. That's not a part of any Creative Commons license. Sometimes the link is to a site totally unrelated to the photo. In all cases, this is a nasty little scam. So all of this is the ugly, risky world of Creative Commons. Remember, you get almost no legal protection from them. If someone sues you for anything regarding the licensed content you use, you are on your own. Last I checked, Creative Commons had 1.6 billion items under license and only got involved in 12 to 14 court cases since 2001. These were not defending individual users like you, but were more general in nature. You will have to defend yourself, And win or lose, these legal cases cost a lot of money. Well, what's the bottom line? Well, know what you're getting yourself into. Creative Commons can be high risk unless you are very careful. You've seen the reason Creative Commons exists and the scary parts of it from my perspective. But ultimately, the choice about using Creative Commons is up to you. Have a great writing day.